Thank you all in the audience for attending. And well, let's get going. I'd like to first introduce our panelists. We are pleased to have with us today Mike Renaud, who is the firm-wide chair of the IP division at Mintz-Levin, where he leads an international team of IP prosecutors, litigators, and transaction specialists. Mike was at one time an engineer, and I actually did my homework on this. I think he was an engineer at Textron Lycoming some time ago, but now has 20 years of experience in IP, is widely recognized as an IP thought leader. We also have with us Shival Vermani, who is the vice president and head of mobile licensing at InterDigital. Shival was previously with a number of entities, including Western Digital SanDisk, Rockstar, Infineon Technologies, and was a staff attorney as well as at the ITC, as well as a patent examiner. We also have with us Larry Tedesco, who joins us from the Berkeley Research Group, BRG, where he's a managing director serving as an IP expert, performing valuations, damages analyses, and providing general licensing strategies. Larry has extensive experience in patent licensing and damages, including experience as a senior vice president at US Ethernet Innovations. I thank you all for your participation, and please note that the opinions expressed by our panelists are their own, not those of their respective organizations. So to kick this off, Mike, maybe you can lead the discussion on the state of SEP enforcement at the ITC, if you would, please.
Sure. Thank you for the introduction, Charles. Thank you, Wendy. And obviously, thanks to Shival and Larry. We got a great panel, so I'll hop right in. So just kind of setting the table, why are we here talking about SEPs and the ITC when it is true that, to my knowledge, the ITC has never actually issued an exclusion order on SEPs? Well, the realities is there has been a long history of case dynamics in regard to standard essential patents worldwide, and the ITC is no different. There was a famous case, which was Samsung versus Apple, in which the U.S. trade rep had a recommendation from the commission to enter an exclusion order on SEPs, and the U.S. trade rep elected not to, essentially overly simplified, because there hadn't been a finding regarding whether there had been holdout or hold up. So that was a unique circumstance. It's highly unlikely to be repeated. And more recently, Chief Judge Bullock recommended an exclusion order in a standard essential patent case for patent owner Netlist against SK Hynix on the JEDEC standard directed at certain memory technology. That was reversed by the commission on grounds that were not related to any public policy issue regarding standard essential patents. Effectively, overly simplified, it was a finding of non-infringement in regard to the case. So the door is open in regard to when will there be an exclusion order issued by the International Trade Commission. And part of what we could explore today is some of the dynamics in regard to how the ITC functions on cases of this kind. So I'll hand it back to you, Charles.
Yes. Well, thank you. Can we turn to the topic of injunctive relief for the SEPs in the U.S. and specifically talking about is injunctive relief for SEPs available in the U.S.? I don't know, Mike. Do you want to lead that?
Sure. I'll take the first shot. Consistent with my opening remarks, notwithstanding the fact that there has not yet been an injunction in an SEP case at the ITC, there is no legal prohibition against such an event occurring. More recently, there have been a kind of a shortage of cases of this kind at the ITC, but there is, in fact, there is no legal jurisprudence that says you cannot get an injunction. Rather, there are prior decisions that would indicate that you can. So I would say the door is open. It's just waiting for the right case. Shival, do you want to offer any of your thoughts? And then I'll move to Larry in regard to, actually, why don't I start with Larry? Why don't you give me your thoughts, Larry, on recent ITC activity in regard to SEPs?
Sure. That's great, Mike. Are you talking about specific areas or
yeah, most specifically
comprehensive strategy?
Yeah, more specifically, one of the recent cases that has been the subject matter of some deliberation at the ITC involved the Nokia complaint. Any thoughts on that?
Right. Yeah, so last year, Nokia filed a complaint with the ITC asserting that certain SEPs related to the H.264 video standard were infringed. And in that complaint, Nokia named several Lenovo entities that were located around the world as respondents for Lenovo's importation of certain computers and tablets. In that investigation, Nokia argued that it went to the ITC as a last resort, really, after a year or so of attempting to license the patents to Lenovo on RAND terms. And as part of that, Nokia labeled Lenovo as an unwilling licensee.
And in regard to that, there was some interesting dynamics in that case. We've discussed them before offline, Cheval, a little bit about the motion that Lenovo prevailed on in regard to getting the licensing history. And any thoughts on how that played out and how that might play out in the future?
I mean, I think you always see these broad discovery requests. I mean, I don't know what that discovery request, I know some folks that work for you brought that to my attention. That case settled, obviously. It's probably negotiation history is probably what my guess is the implementer was looking for in that case. And you'll see that attempts of that made, and then obviously attorney-eye only involvement on licenses. So you will see some, I think, fairly broad discovery. It's been a number of years since I was an ITC attorney, so I can't remember how much broader those discovery requests can be. But you're going to see them there. Mike, can you just repeat the question? I might have lost track of it initially. What the broader?
Yeah. So there was a administrative law judge, Lord, ordered what appeared to be extensive discovery regarding the back and forth over a 10-year period between Lenovo and Nokia, and just wanted to get your sense as to the case settled. The Nokia dispute with Lenovo settled relatively quickly, so we didn't get to see how that played out in full. I just thought your reaction to that.
Yeah, look, I mean, 10 years is quite a long time, and it probably was the negotiation history surrounding that program and those patents. I think what that case is a little unique. If I remember, there was a North Carolina case that was at least a year ahead of that ITC case. So, you used to see the ITC and district courts cases filed really close together, maybe the same day, maybe a couple of days apart. That case was brought probably a year after the district court case was brought. And that was a little bit unique in some ways on what you're seeing in at least, SEP enforcement 1.0, which we're past that now at the ITC. So I think that was a unique thing that wasn't there, but obviously that case settled. So I'm assuming both parties are happy with the result, because it settled pretty quickly after the complaint was filed, I think. Yeah,
and my observations along the same lines were, since the respondent, which is the defendant in the ITC, has the burden to show that there was some unwilling licensor dynamic if they want to use a defense of, hey, they haven't met their obligations as an SEP licensor. That's an affirmative defense. So the burden is on the respondent. In this instance, Lenovo, in my opinion, was fishing for holdup information, right? If they can show holdup, then the SEP dynamic regarding whether or not there was a willing licensor would be undercut. So I think, ultimately, while I don't have confidential information that would tell me what the background of that request was, to me, it was an attempt to find information that would support hold up. My reaction, by the way, is it almost de facto can't be hold up if it was a 10-year period of back and forth. So in any event, Cheval is correct. That case settled relatively early. Further to the injunction question, I guess, that Charles posed, the open question, I guess, would be any thoughts, Cheval, juxtaposing, say, the opportunity for the injunction at the district court versus the ITC? Any sense as to how the SEP dynamics play out between the two?
In other words, where a party might have more visibility into the result, district court versus ITC?
No, I was thinking more like if you had to intuit whether or not you were more likely to get an injunction at the International Trade Commission on an SEP case, all things considered, versus a district court case? Same parties, same patents. Any instinct on that?
That's a really tough. I don't think anybody's got a crystal ball. I think I might give the slight edge to the ITC right now. I think judges are human, and I think just like federal circuit judges, district court, ITC judges, I think they see what's going on in the SEP dynamic in other countries, and I think that they look to those and see what happens in those countries and the facts that are developed, and they're more likely seeing that there's much more hold out that's quantifiable than there is hold up, and I would think that some of that would be influential. I don't know it would be, but I would think some of that would be influential with an ITC judge, as you see some of these cases get filed or go through the system.
And Larry, kind of in the same, I know you've been involved in many SEP cases at the district court involving the damages analysis, the issues of hold up, hold out. Any sense on your end as to a comparison between ITC versus district court as to how you find perhaps, are they complementary? Is one better than the other in your mind? Any instinct on that?
Yeah, well, I in my experience, I've been lucky to have been able to work with a diverse range of SEP holders. Some are large and some on the smaller side. And I think, oftentimes kind of the overall strategy really depends on where an individual is located. If they're a target, what part of the world they're located in. And for certain companies that are outside the U.S., there may be less concerned over the ability, of obtaining injunction relief. But, as you just said, I think holdout has become it's become so pervasive here over the last 5, 6, 7, 8 years that ITC is one of the places that it can be dealt with.
And just to follow up on that point, Larry, since you don't have to set a rate at the ITC, right? It's a much more simplified analysis in effect, because if the respondent can't show hold up, then the analysis is over. So the present state of the law, there is no rate setting, there is no expert discovery required in regard to some of the protracted analysis and discovery that the experts have in district court. So I frankly believe that the bar is lower on the SEP piece. And before we move on to the next subject, I know that there's been talk of a pilot program, using the pilot program, the new pilot program that's been put in at the ITC, to perhaps investigate, right up front, whether there's been hold up versus hold out. It would bring almost shades of the willing or unwilling licensee hearing in the UK. Cheval, why don't I start with you, and then I'll ask Larry. Any thoughts or comments on whether that pilot program might be something that the patent owner or the respondents might use for purposes of willing or unwilling licensee?
So, Mike, I'll let you, I know you're closer to the ITC day to day. I'll let you correct me if this is procedurally possible, but I don't think it's too far off from a complainant getting ahead of some of the issues that I think are more sensationalized in these discussions and litigations. And I think a complainant will try to build a record to show that the licensee or respondent is indeed unwilling, and to try to get that information into the judge before there's a finding or contemporaneously with a finding of infringement and the other issues that I think are very important in ITC matters, putting aside patent validity in 101, and then obviously domestic industry. I would think a complainant would try to get that information into a judge's hands earlier. And Mike, I'll let you correct me. I think the challenge would be that a lot of that information that is FRAND related and willing or unwilling, hold up or hold out, goes into the public interest phase of a case. So I think the challenge is to try to get it in earlier if you can, and then what's the value of that information to a complainant or a licensor. But I would think that that's inevitable. I don't know what the judge's reaction will be to that, but if there's a 100-day pilot program to possibly interject a motion like that into a case, I think you're going to see attempts at that made.
And I'll just make a really quick answer. I agree, and overly simplified, since they're delegating public interest in most cases these days, I actually think that you're right. It is inevitable that we'll see a pilot program hearing of that kind.
Let me move us on to the next topic, but rolling that in, I'm hearing from Larry's comment that the possible resolution of holdout at the ITC could be efficient. Mike, can you comment on and lead the discussion on the ITC as part of a comprehensive strategy?
Yes, I will. That's a great question, Charles, and I'll try to limit it to kind of a U.S.-centric approach, because I think there's some international contours we'll cover later. But overly simplified, I like the idea of having both an ITC and a district court approach when one is looking to drive licensing outcomes as a patent owner. There are past examples of that. I mean, Ericsson famously pursued Apple in both the district court and ITC, not only on the same patents, but on different patents. And so what that allowed for is that there is an absolute right to stay a district court case. The defendant can stay a case in the district court if it's on the same patents as the ITC. What Ericsson did, which I thought was rather clever, was file 4 or 5 district court cases on patents that weren't in the ITC, so they couldn't get stayed. And in that instance, there's a lot of Monday morning quarterbacking about what did or didn't happen. But at the end of the day, Apple settled right before the first of 2 ITC cases, which were scheduled to go back to back. They settled right before that occurred. And as a result, neither Ericsson nor Apple got to hear the outcome of a high stakes SEP case. So I think that the ITC was a major driver in that resolution. So when folks say, yeah, but there's never been an exclusion order, I offer that as an example where, but for those ITC cases, I don't believe Apple would have resolved their disputes with Ericsson. So back to the question about the comprehensive strategy, Charles, I think it varies, like Larry said, depending upon the size of the patent owner, the size of the defendant / respondent. But I generally think that you would need to bring the ITC as a complement to a district court strategy, not in lieu of one. I think they can move nicely in parallel. And then the interesting question is, do you add an extra district court case that has different patents so it cannot be stayed? So you have multiple fronts. And my short answer is, if you have the resources and you have the patents and your price requirements are high, your expectations for settlements are high, I think you're kind of compelled to take that approach. But certainly turn it over to Cheval and Larry for their thoughts on that. Why don't we start with Larry?
Sure, Mike. I think Ericsson versus Samsung and Nokia versus Lenovo last year were good examples of a broad strategy that included the ITC. Ericsson, as a lot of you know, sued Samsung in the Eastern District of Texas in December, and then they followed that up with a complaint to the ITC in January. But as you were saying earlier, really didn't stop there. They also followed suits multiple places in Germany and in Belgium, and so the ITC was obviously a part of their overall strategy. Likewise, we saw in Nokia and Lenovo that there were lawsuits between the two companies ongoing at the ITC, but also in India, in Brazil, in Germany, also in a couple of the federal courts here in the U.S. So, I think those are two good examples of a broad strategy, including ITC.
And Cheval, your thoughts on that? How the ITC would be part of a comprehensive strategy?
Yeah, look, I mean, it definitely, I think the days of where a complainant or a patent holder is, doesn't have any options left, has to sue, and then says to itself, I'm going to file one case that's going to be in the ITC and I'm going to see what happens. I don't think you're going to see so much of that. I'm not saying it's not going to happen, but I do think it's part of a more comprehensive global strategy, especially for a lot of the major SEP holders. But that being said, I don't know that a lot of SEP holders look at the ITC the same way. And what I mean by that is, I think some will definitely pursue SEPs there. but some will maybe pursue their SEPs elsewhere and use the ITC for implementation patents. In the Ericsson case, and I don't know this, so someone can correct me factually, on the recent Ericsson Samsung, which all settled fairly quickly, Ericsson's ITC complaints were all on implementation patents. Now, I don't know if that was a strategy choice to focus on implementation patents, or it had to do with the injunction or the anti-suit injunction out of China. I'm not sure what played a role in that, but there's a major SEP holder that elected not to pursue SEPs in a broader campaign. And I think the SEP enforcement was dealt with elsewhere in other countries and maybe in district court. So I definitely think it's going to be part of it. I think it changes. It's pretty fluid whether or not a company says, I'm going to go with SEPs in the ITC or implementation, or two separate complaints, an SEP complaint and an implementation complaint, if you've got the resources to do that.
Yes, you're correct. There has been a mixed series of approaches. You're right. The Samsung Ericsson dispute, as best I can recall, Ericsson did not assert SEPs at the ITC, which is intriguing. But they did have them in the district court case. So there's a lot of mixing and matching going on. The other strategy that I've heard that I think is actually sound is saying if there are near SEP or impactful, the patents are impactful to the standard, but they're not standard essential, those are a nice set of non-SEP patents to assert in parallel with the SEP patents. And there's some tension between how you defend when you have both flavors of patents in play. So there's even been cases where there's been a mix of SEP and non-SEP patents. So agree that those have all been strategic options that have been explored. And I think one of the things that gets lost is that there continues to be a full array of strategic options available. There have been no findings that would close the door to any of the different flavors of approaches regarding mixing SEPs or not, or including them in the district court and then maybe in the ITC, or even whether or not to have a mixed set of cases globally. I think for purposes of transitioning, Charles, is it time to move on to the next topic?
It is, in fact. Well, you've done a good job of teeing it up, because the last topic is your thoughts on global SEP disputes, and you kind of led up to that, and I'm anxious to hear what we can expect. It's been a hot area, and it sounds like it likely get hotter on a global basis, and maybe you can reflect on how that might influence the ITC also.
Sure, and I do think it is a hot area, and one of the ways that you see strategies laid out is by heat maps, where folks will say which countries impact which potential licensees. So it's not unusual to see certain Chinese handset makers who don't have significant market share in the United States, or have zero market share. Let's take Xiaomi, essentially has no market in the United States. They have a large market in India. So filing an Indian case has been fairly routine in the last few years in regard to a strategy to pursue Xiaomi. Similarly, Motorola, Lenovo have exposure disproportionately in Brazil. So bringing cases there has been a strategy. Those strategies have been used, what I'll call, in non-SEP cases, and they're increasingly being used in SEP cases. So my short answer before I pass it to the other panelists is, I don't think I've seen a major licensor do a single country approach unless that first filing generated an outcome very quickly in the form of a license. All of these, all of the what I'll call the big four, which to me are Nokia, Ericsson, Qualcomm, and InterDigital, the big four of SEP holders, none of them, I think, have done a single country strategy unless it is borne fruit very quickly. So I think, and it has spilled over into other standard setting battles. It isn't just 4G and 5G. You're seeing a whole array, as Larry mentioned earlier. The Nokia case against Lenovo is an H.264 standard setting case related to codecs, and the Netlist case that I referred to earlier, in which Judge Bullock recommended an exclusion order and the commission reversed, was the JDEC standard. So, and that those cases, by the way, for Netlist weren't limited to the United States. There were also cases in Germany. So anyway, I'll turn it over to Larry and Cheval. Cheval, what are your thoughts on incorporating multiple jurisdictions beyond the United States in these matters?
I mean, I think that's the ship has sailed on that. That's happening. That is almost part of any licensor's thought process before it undertakes a litigation or multiple litigations. I think the idea of just filing one case, it's been a while since that's happened. So I would agree. It's a lot of things. It's what relief can you get in what country, what the sales might look like in that country, the judge's hostility or non-hostility towards types of relief and towards patent owners. I think all of that plays a role in how a selection is made. And I think, the timing of cases, when there might be a window in which there's more pressure versus less. I think all these things play a role in the selection and sequencing process of these litigations.
Larry, your thoughts?
Yeah, I mean, I agree with that. I've spent a fair amount of time recently looking at Germany, specifically, and as many of you know, their default remedy when infringement is found is an injunction, a de facto injunction. However, they recently passed a bill which, among other things, it contains a codification of a proportionality test, which measures, basically, it provides the courts there in Germany with an express basis for a temporary or permanent suspension on the injunction against a fair competition, in addition to potential damages for past infringement. So the test, it takes into account the interests of third parties.
Yeah, and just to follow up on that, Larry and I have had conversations in the past about, some of the efficiencies that arise from a comprehensive multinational strategy. While I think, Larry and his team at Berkeley Research have really mastered the analysis on what constitutes a FRAND rate or setting a rate card in the United States, they also have a full appreciation for it internationally. So what's interesting is I think the work that you do to work up your case on the FRAND issues in the United States apply without a great deal of extra effort to these other foreign jurisdictions. So, going back to you, Larry, first, any sense on the efficiency, meaning how much extra work is it to prepare and support a case in a different country beyond the United States once you've worked up your U.S. case?
It isn't too much. I mean, I think most of the time what we do in the U.S. now is used around the world, and that's probably more so, I think these days than it was maybe 10 or 15 years ago. But a lot of what's happening here in the U.S. is also being, that also happens around the world too. So it isn't too much extra.
And Cheval, any sense on the efficiencies? Leaving aside, there's obviously enforcement benefits in having more than one country and their associated sales, but any sense of the efficiencies between multiple countries?
I can't speak to the efficiencies with a high degree of confidence in meaning if it's efficient or not, because our litigation group handles that and they're very good at that. But I think there's a lot of work when you have multiple litigations going on, I think, for both parties to coordinate all the effort, and depending on the number of patents involved, it's definitely more work than one case, I think, for sure. So it's efficient because I think it may lead to a resolution, but I think to get there could be a little more work than you would have seen 10 or 15 years ago.
Yeah, and I do think that the amount of incremental work has gotten smaller each time we've been involved in a multinational effort. And the reason, of course, is there is heightened coordination between lawyers and experts in different forum. So there really is an efficient machine, I think, for those who do this routinely. And I'd even say that on the FRAND piece in particular, when you employ a sophisticated shop like Larry's or any of the other top shops, they know how to actually gather up the information such that it could be deployed really efficiently, regardless of which country you're in. I also think on the infringement side, meaning the technical subject matter of the case, that the same is occurring, meaning the law firms that you're working with in India, in Germany, in the UK, and Brazil, et cetera, are all seemingly increasingly sophisticated in how they can pick up and organize. So I really feel like as the implementers have gotten pretty good at resisting taking licenses, the innovators have gotten pretty good at organizing to pursue them for licenses. So I think that you're right, the ship has sailed. It is an international marketplace now, and perhaps to a degree that exists nowhere else in patent litigation or in IP litigation. The SEP market for dispute resolution is truly international in every sense.
And I think, I think also, Mike, that maybe over the last few years, I think that the approaches on the damages side and on licensing have become more similar between the US and what you see in Europe and around the world, whereas maybe they were more separate years ago. We're finding that a lot of the analyses that the courts are supporting and experts are using are a lot more similar now than they have been in the past.
Yeah. Well, that's good. I'd like to thank you for this engaging discussion. I'd like to transition to the question and answer period of the program. So again, thank you. And in inviting questions from the audience, there are two ways that this can be done. You can type your questions into the Q&A box. That's the Q&A box, not the chat, where we'll bring those questions to the panelists, or you can raise your hand using the icon at the bottom of your screen. And if you do that, we can bring it to the stage, but remember to have your video and audio enabled. And then when you come on stage, please state your name and organization, and most importantly, your question. While the questions come in, I'm going to lead off with a question, if you don't mind, Mike, and I'll throw this one at you, but you can send it off to the panelists. And that is, where are we at with determinations of essentiality? I know my experience in MPEG was, MPEG spent a lot of money, and as I understand it, they're still spending money, or the video organizations, to determine essentiality, whereas other standards are based on a declaration of essentiality, which I also understand you can frequently get into a dispute and patent holder may claim a dozen or several dozen patents to be essential to the standard, and upon further research, turns out that not so much. Where are we at with that? Is there any convergence, or is it divergent depending on the standard, whether it be video or 5G?
So really interesting developments going on in essentiality. I guess to try to take it at a high level, when essentiality is challenged in the context of a litigation, ITC or otherwise, significant sums are spent by the respondents challenging essentiality, because that usually results in an infringement problem if the patent is essential. And then the patent owner, obviously pressing to say that there's infringement because of the essentiality. That's the standard battle. So you will have hundreds of thousands of dollars, if not millions, spent on that issue in a large case, if it's an ITC or district court case in the United States. So the context that you're talking about, where someone self-declares essentiality, or even if there's a outside third party like a law firm with subject matter expertise certifying they're essential, the scope of investment there is dwarfed by the litigation investment. So even if you spent $50,000 per patent, and you could imagine that with thousands of patents within a standard, it's probably not likely that folks are spending $50,000 per patent assessing essentiality. But even at $50,000, it's a fraction of what's being spent challenging the essentiality in a large dispute. So there is no real way to duplicate the essentiality attacks or defenses that occur in a litigation in the pre-litigation context. And just like most patents that get issued by the U.S. Patent Office, and there's over 10 million now, never see the light of day. They never get used in any capacity. They never have a discussion about them in the form of a dispute in a court. Most SEPs don't either, right? So there's never going to be a day where we're going to spend the same amount of attention on the patents that are not asserted as those that are. There is an attempt to use artificial intelligence to solve this problem in determining essentiality. It's not ready for prime time. It has some benefits, but it's not ready yet. So in my mind, the essentiality battle is going to last for the indefinite future, although there is an interesting set of dynamics. Should a judge decide it? Should a jury decide it? When should it be decided? So we've seen some clarification of those decisions within the U.S., but anxious to hear Cheval and Larry's thoughts on it. Cheval, why don't I hand it to you?
Yeah, I mean, look, I think the patent pools or platforms will deem potential licensor members' patents essential so they can quantify what part of the pool revenue that they should receive. So there's that. But even then, those pools still have to assert their patents. And some of those, I think the video pools have asserted their patents in Europe. So I don't know that. I kind of agree with what Mike is saying. I don't know that there's really a solution to this. If there's, I think there's some third parties that will evaluate portfolios, cellular or video, held by different companies to give a guide to the market and their opinion on what's essential. But again, it doesn't duplicate. I think, I think it's helpful, but I don't think it eliminates, unfortunately, the need for some litigation.
Well, I think I'm going to interrupt because we have a question from the audience, but I think you've summed it up, and certainly there's no test like that of litigation to determine if something is not only essential but valid. So I get that. The question we have from one of the audience members is Larry Rosenberg, who's with CRA International, asking, are you starting to see 5G litigation, 5G SEP litigation in the district courts or the ITC? And I'll let whoever wants to run with that.
Larry, do you want to take the first shot at that?
Yeah, sure. We're just starting to see that now in the district courts. I'm not as sure with the ITC. You probably would know that more than I would, Mike, since you spent a lot of time there. But just over the last few months, starting to see some activity around this area in the district courts. Obviously, I think it's going to pick up a lot over the next year or two. But just in our experience over the last couple of months, I've seen some.
Yeah, and I would say you're right. I'm not aware of a 5G standard essential patent being asserted at the ITC yet, although certainly some of the 4G patents have read on 5G functionality. That's kind of a hybrid dynamic. I think it's inevitable that a 5G patent will be asserted at the ITC if there isn't a present case, and I don't believe there is. So it's just a matter of time. Cheval?
I mean, look, the market has embraced, some of the top 2 or 3 or 4 OEMs. They've embraced 5G. They're probably selling, next year we'll have more 5G phones than 4G. It's inevitable. I don't know of any right now. I feel like I read it somewhere on IP Law 360 of a 5G case, but I couldn't cite one right now to the question.
Well, thank you. We also have an audience member, Karmanya Singh, and I'm going to bring him on stage. Hello, Karmanya.
Hello. Hi.
Hello.
Hi, I'm Karmanya. I'm from Comet, based out of Delhi. And my question is essentially how useful are injunctive relief decisions in different jurisdictions for other jurisdictions? Are you able to rely on them? Or is it a sort of argue again situation in different jurisdictions when you litigate?
I guess I'll take that in 2 parts. I think they're very important for other jurisdictions, although I think partially because of the injunction battles that arise, right? So getting an injunction usually creates a request by the company being enjoined that it get a court that's more favorably inclined to its position to issue an injunction that says that injunction can't be ordered. But separately, I can tell you at virtually every hearing in Germany that I've been to, and I'm not limiting this to SEPs, there'll actually be strong awareness of what's going on in other courts. The German courts are very attentive and very sharp on issues of what's happening in parallel proceedings. As an example, if there are IPRs pending in the United States, they want to know, is the petition been granted? What's the art? When's the final written decision due? So the And, more recently, I was involved in an ITC case where the German proceedings were brought up as evidence that the patents were invalid because the German patent or not infringed. Both issues came up depending upon what happened there. So correspondingly, an injunction, which is more important than any other part of a proceeding in my mind, would have some level of significance for courts in other jurisdictions. The standards are different, the claims are different. So I don't believe they're persuasive, but it definitely helps your cause if you've gotten an injunction in one jurisdiction and you're pursuing an injunction in another. I don't think it hurts. Now, there's always the wild card with China. I think that's a little different. But Cheval, Larry, do you want to pick that up?
I agree with that, Mike. I mean, obviously, adds a lot of pressure when you get an injunction, and since there are only so many places in the world where that's even possible right now, I think it adds a lot to any litigation anywhere.
Yeah, I think the Indian courts are becoming very sophisticated, very, very fast. I think 2 or 3 years ago, I think there was a desire by some of those courts to just see what's going on in the UK or Germany and the States, especially on SEP case law, on maybe the economic side and friend. But I think as India develops its system, and it's done a very good job at that, I don't know how much more they're going to follow, but I do know that the judges there scrutinize what's going on in the rest of the world. I believe that's true, really. Honestly, I believe that that's true in Germany, the UK, and I believe it's true here. I think judges are human, and I think they have a pretty good awareness of what's going on in other countries and what the other countries are doing on certain issues.
Yeah, I think that's interesting because how Michael says the claims differ, but how you see in SEP litigations in Delhi at least, a lot of the times the judges do rely on how similar the claims are, and with new IP divisions being set up in courts, I think even though judges are sometimes less technically qualified for this, it gives them the confidence to grant injunctions when there are other injunctions in place. So yeah.
Yeah, my personal experience, the judiciary showed a lot of interest in wanting to know what's going on in other parts of the world with other companies or the same company. They showed a tremendous amount of interest in that.
Well, thank you very much, Carmania, for that question. Excellent. And thank you to our panelists. We'd like to move on to the networking part of the program. First of all, a big thank you to the panelists and audience members for such an engaging and insightful discussion. We're going to head to the lounge where you'll have the chance to connect with one another. When you get to the lounge, you'll see 2 options. You can select the speed networking option up top, where you'll automatically be matched for 3-minute speed meetings. Below that, you'll see our table chats. Today, we have these set up where you can start off at your appropriate last name table, which are tables 1 through 5. Then if you'd like, you can move to any of the other topic or theme-based tables or hop up to speed networking. Feel free to make your way to the lounge, get comfortable, say hello, catch up with colleagues. Just make sure you have your audio and video on for best networking experience. If you prefer audio only, that's fine. You'll even see a table set up for that in the lounge. Now, before we head over, I'd like to take a moment to thank our speakers once again, and of course, our sponsor, Mintz, for making this event possible. Last but not least, I'd like to thank you all for joining us. Our Disruption series will continue with a second ITC-focused webinar, also to be sponsored by Mintz at a date soon to be announced, so stay tuned. And now we will head to the lounge, and I'll wish you all